Hey guys, we are going to come through 2 lectures this week and a quiz, so bear with me. Let's dive into the American legal system and the courts. We have this cherished narrative in American politics that says that justice is blind, and the Supreme Court is this like apolitical dispenser of it. The Supreme Court, though, is actually pretty political. There's no more classic example of this in the 2000 presidential election between George W. Bush and Al Gore, when there was a 5-4 decision that elected George W. Bush as our president. Alexander Hamilton wrote in the Federalist Papers that the Supreme Court would be the least dangerous branch of the government. Neither power of the sword or of the purse can do little other than judge. No raw power or politics involved. But 200 years later, the Supreme Court took a very political role of deciding who would be our next president. We need to imagine our world without laws, right? Say you can speed, you can park wherever you want, you can enter a store that sells all sorts of drugs, purchase what you like without proof of age or prescription, no rules that govern the production of our currency either, so you really hope that whoever is giving you all this is going to accept what you have to trade. Then your car's stolen, but it's not illegal, so there's no cops to call anyway. We're looking at like a Lord of the Flies sort of situation here, right? In chapter 1, we talked about Hobbes and Locke, who imagined this like pre-political world without laws. Hobbes said it would be a solitary, poor, nasty, brutish, and short life. Locke said maybe it would be inconvenient, and you'd have to constantly be on the defensive. But Hobbes and Locke thought that people would be willing to leave the state of nature for civil society, to give up their freedom to do whatever they wanted in order to gain security and order and predictability. We focus on laws that stop us from doing what we want to do. We don't think about the laws that allow us to live together peaceably. Laws are the how and who gets what and how of politics. They dictate how collective lives are to be organized, what rights we claim, how to use the system to get what we want. Laws can also be the what, as citizens and political actors use the existing rules to create new rules that produce even more favorable outcomes. There are laws and limitations that get in our way or make our lives easier, but our legal system is also founded on rules that represent basic and enduring principles of justice that create a higher level of civilization. Laws are the product of a political process created by political human beings to help us get valuable resources, which could be civil peace and security, moral order, power and influence, or even goods and entitlement. For security, we have like laws that ban violence. For moral order, we have laws against murder. For political advantage, we have laws that maybe give a larger state greater power in the process of electing a president. Then we have laws that deal with more concrete resources, like giving a tax break to a homeowner or subsidizing a dairy farmer. Different political systems produce different systems of laws. There are small communities where folks share values and experiences. A formal legal structure may be unnecessary since everybody knows everybody and understands what's expected of him. And then there's authoritarian systems like North Korea or China, where laws exist primarily to serve the rulers in the state, and they're subject to whim at the rulers in the state. And there's systems that merge church and state, like maybe the Holy Roman Empire or some Islamic countries today, where laws are assumed to be God-given, and the violations of the law are analogous to sinning against an all-powerful creator. In non-authoritarian, why do I have a hard time saying authoritarian? Non-authoritarian countries where citizens are more than subjects, we could make claims of rights against the government. Laws are understood to exist for the purpose of serving the citizens, even if they have like the ability to restrict our actions. Laws and the courts that interpret and apply them perform a variety of function in democratic societies, some of which we commonly recognize and others that are less obvious. There are 5 important functions of laws. The first is law that provides security so we can go about our daily lives in relative harmony. The second is that laws provide predictability that allow us to plan our activities in business without fearing a random judgment. The third is the fact that laws are known in advance and that they identify punishable behaviors that lead to the conflict resolution of laws in a democracy through neutral third parties known as a court, which is the institution that sits to resolve conflicts. Fourth, our laws reflect and enforce conformity to society's values, for instance, that murder is wrong. And fifth, laws that distribute the benefits and rewards that society has to offer. And they allocate the cost of these good things, whether they're welfare benefits, civil rights and protections, or tax benefits. Most governments have a legal system founded on a civil law tradition based on a detailed, comprehensive legal code that's been usually it was generated by the legislature. This is a civil law tradition. Some of these codes date back to the Napoleonic era, and these codified systems leave little role to the judge's discretion in determining what the truth of the law is. what the law is. The judge takes an active role in getting to the truth. The judge investigates the facts, asks questions, determine what happens. There is an emphasis on getting the appropriate outcome instead of the integrity of the procedures. The procedures are important. The United States is different in a lot of ways, but three important ones. We have a common law tradition, not a civil law tradition. We have an adversarial system, and we have a litigious system. So here, instead of the civil system, we have a common law system, which is based on the accumulated rulings of judges over time that are applied uniformly. This is judge-made law. There's an emphasis on preserving decisions that have made before, which is called relying on precedent. Stare decisis, let the precedent stand, let the decision stand. You guys, I always tell you, like, we're taking law school really quickly in this class. This is an entire class of law school. Judges have far more power in determining what the law is than do judges in a civil law system. And their job is to determine and apply the law as an impartial referee, not take the active role in discovering the truth. The United States is not purely common law. Legislatures do make laws, and attempts to have been made to organize them into a coherent body of law, but legislators are less concerned with creating a coherent body of law than with responding to their constituents' needs. American law is a little bit hodgepodge, but it's common law that is reinforced by the fact that judges still use their considerable discretion in deciding what law means, and we rely heavily on precedent. We also are an adversarial system, which means that we have trial procedures that are designed to resolve conflict through the clash of opposing sides, moderated by a neutral, passive judge who applies the laws. We also have an inquisitorial system, or as opposed to an acquisitorial system, where there are trial procedures designed to determine the truth through the intervention of an active judge who seeks the evidence and directly questions witnesses. There, the judge is a fact finder. He's questioning the witnesses. We can argue that it maintains a key American principle, innocent until proven guilty, but the adversarial system fits with our cultural emphasis. Why am I not able to talk? Our cultural emphasis on individualism and procedural values, and it gives tremendous power to lawyers, this adversarial system. We also are a litigious system. We sue each other a lot, right? We have more lawyers per capita in the United States than anywhere else. But the large number of lawsuits in the United States is a measure of our openness and democratic concern for the rights of all citizens, and that litigation is unavoidable in democracies committed to individuals' freedoms and to citizens' rights to defend themselves. We sue a lot because we've failed to provide compensation and security from risk. We've also come to expect total justice, that everything bad that happens can be blamed on somebody else, and we need to figure out who can compensate for that. Not all laws are alike, and there are a lot of shades to legal meaning. So we'll look at substantive laws versus procedural laws. Substantive laws are laws whose content or substance defines what we can or cannot do. The actual substance defines it. And then we have procedural laws, laws that establish how laws are applied and enforced, how legal proceedings take place. These establish the procedures used to conduct the law. Because our founders were really concerned with limiting the power of government to prevent tyranny, our laws are filled with procedural protections for those who must deal with the legal system. We have procedural due process, which protects the right of individuals who must deal with our legal system. But sometimes these procedural and substantive laws clash. For example, if the police failed to read your rights, you may be spared punishment even if you broke a substantive law, but the procedural law was also broken. And then you have criminal and civil laws. Criminal laws are behaviors that the government has determined to be harmful to society. The violation of it is called a crime, right? They are referring to crimes against the state, so it's the government that prosecutes these cases rather than like the family of a murder victim. The penalty, if found guilty, will be some form of payment to the public, community service, jail time, even death, paying your debt to society for these actions that were seen as a harm to society. And then you have civil laws that are laws that regulate interactions between individuals. These violations of civil laws are called a tort. And you take an entire law class called tort law. And it was one of my first classes in law school. It's called torts. If one person sues another for damaging his property or for failing to fulfill a contract, that's not a crime against the state, but rather to an individual. So the government's purpose here is not to prosecute a harm to society, but to really provide individuals with a forum where they can peaceably resolve their differences. The government has no stake in the outcome. Sometimes something can be both civil and criminal. And then we also have constitutional law, another law school class. This is the law stated in the Constitution or in the body of judicial decisions about the meaning of the Constitution handed down in the courts. These laws establish basic powers and limitations on the government and their interrelationships. They guarantee our basic rights of citizens. It evolves over time as circumstances change, justices are replaced, cases are overturned, precedent is reversed. Most laws in the United States are made by Congress and by state legislatures, by the bureaucracy, under the authority of Congress and by the president. Statutory laws are laws passed by a state or the legislature that reflect the will of the bodies elected. For example, you have to wear a seatbelt, you have to pay taxes, you stay home from work on Memorial Day, things like that. Judges can declare statutes unconstitutional if they conflict with the basic principles of the government or rights of citizens in the Constitution. Then you have something called administrative law, which is law established by the bureaucracy on behalf of Congress. Legislatures cannot be experts on all matters, so they frequently delegate lawmaking powers to the bureaucracies. And then you have executive orders, which we've talked about before, which are clarifications of congressional policy issued by the president and having the full force of law. Americans may owe a lot of our philosophy of law, called jurisprudence, to the British courts, but the court system we set up to administer our law is uniquely our own. The nature of the judiciary was the subject of hot debate during our founding. Large states were comfortable with a strong court system as part of the strong national government they advocated. Small states, cringing at the prospect of national dominance, preferred a weak judiciary. Founders left it to Congress to settle. And so in Article 3, Section 1, they said the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress may from time to time ordain and establish, and that justices may hold their jobs for as long as they demonstrate good behavior. So they're appointed for life. It doesn't really spell out the powers of the Supreme Court, only what cases come to the Supreme Court. And then the Judiciary Act of 1789 starts to fill in the gaps on how it's going to be organized. The idea of an independent judiciary headed by one Supreme Court was new to the founders. No other court had this. Britain's highest court was also its parliament, which was their legislature. So it puts a lot of faith in the idea of separation of powers and checks and balances. An independent judiciary was an ideal way to check the power of the president and Congress, and an important part of the narrative being created about a limited power, but to others it created this unknown threat. So Hamilton in Federalist 78 was trying to argue that the judiciary was the least dangerous branch of the government because it lacks the teeth of the other branches. It can exercise neither force nor will, but merely judgment. Several of Washington's appointments turned him down because they thought this was right. They didn't think it was very prestigious to serve on the Supreme Court, and they left for a more prestigious position. When the capital was moved to D.C., the planners forgot to design a location for the Supreme Court, and for that reason, the highest court in the land met in the basement of the United States Senate. If you ever are touring the Capitol, if they ever let us back in, be sure and ask to see the old Supreme Court chambers. It's really neat. But they eventually moved them across the street where the Supreme Court is today. But this low prestige didn't last long, and almost single-handedly because of John Marshall, he established something called judicial review, which is the power of the courts to determine the constitutionality of laws. So in Federalist 78, Hamilton dropped a hint that he would approve of a stronger role for the court. So answering critics that declared that judicial review would give too much power to a group of unelected men to overrule the will of the majority as expressed through the legislature, Hamilton said the reverse of this was true. Since the Constitution was the clearest expression of public will in America, by allowing that document to check the legislature, judicial review would actually place the true will over momentary passions and interests that were reflected in Congress. The Constitution does not give the power of judicial review to the court, but it doesn't forbid the courts to have that power either. In Marbury versus Madison, this is the landmark case that established the Supreme Court's power of judicial review. The case involved a series of presidential appointments to federal courts made by the final hours of...
I didn't get that. Could you try again?
I was not talking to you. The letter appointing William Marbury to be the Justice of Peace for D.C. was overlooked and not delivered. My watch thinks I'm talking to it. The midnight and last-minute appointments irritated this new president. Thomas Jefferson wanted to appoint his own candidate, so he had his Secretary of State, James Madison, throw out the letter, along with several other appointment letters. According to the Judiciary Act of 1789, it was up to the Supreme Court to decide if Marbury got this appointment. This put Marshall in a fix. If he exercised his power under the act and Jefferson ignored him, the Supreme Court's already low prestige would be severely damaged, but if he failed to order the appointment, the Supreme Court would still look weak. So instead of ruling on the question of Marbury's appointment, he instead focused on the part of the law that gave the court the authority to make that decision. He found to go beyond what the Constitution had intended. That is, according to the Constitution, Congress didn't have the power to give the court that authority. So Marshall ruled that although he thought Marbury should get the appointment, he shouldn't enforce it because the relative part of the Judiciary Act was unconstitutional and therefore void. And he justified the court's power to decide what the Constitution meant by saying it's emphatically the province of what the judicial department is to say what the law is. So Marshall chose to let us lose a small battle in order to win a very large war. He created this power of judicial review, which vastly expanded the political influence, the potential influence of the Supreme Court, and set it on the road to becoming the powerful institution it is today. What would the public reaction have been if Congress had voted to make itself the final judge of what was constitutional? Judges are aware of the enormity of this power, so they use it pretty sparingly. Not much from its inception in 1803 until about 1859. And then since then, it's only been used about 160 times to strike down acts of Congress. It's used a little more to invalidate something that's done in the state legislatures. So Congress's response to designing a court system immediately put together the Judiciary Act of 1789, but the system created by this act was too simple to handle the complex legal needs and the growing number of cases in the new nation. Congress gradually crafted a very complex network of federal courts that we have now. We have two separate court systems, the state system and the national system. Most things take place at the state system. Jurisdiction is the court's authority to hear certain cases. Most cases in the United States fall under the jurisdiction of state courts. You only go to federal courts for certain things. There are four characteristics to determine what court has jurisdiction over it. The involvement of the federal government, the parties to the case, where the case arose, and how serious of an offense it is. Once the case is either in state or federal court, it doesn't really change. So the original jurisdiction is the authority of a court to hear the case first. And then appellate jurisdiction is the authority of a court to review decisions made by lower cases or by lower courts. So when you appeal, this is a rehearing of a case because the losing party in the original trial argues that a point of law was not applied properly. So the Supreme Court's original jurisdiction is limited to cases that concern ambassadors and things like that. So this is only a couple of cases a year. Most parties in the United States are entitled to, or all parties in the United States are entitled to appeal, though more than 90% of losers in federal cases accept their verdicts without appeals. And after the first appeal, further appeals are at the discretion of higher courts. The Supreme Court is the highest court of appeals of the land, and I hear fussing children upstairs, I'm sorry. Each state has its own constitution, though, and their own set of rules for structuring and organizing its court system. The state systems are remarkably similar and fall into three tiers. There are a trial court, intermediate courts of appeals, and then state Supreme Courts. The judges in state courts are chosen through a variety of procedures. They can either be elected or appointed, and there's not one way of really determining what the correct way of appointing a judge would be. The federal system is also three-tiered. The entry level is called the district court, and then appellate court, and then the Supreme Court at the very top. We also have 94 federal district courts in the United States. So each state has at least one, and the largest states have about four. The Court of Appeals are any cases that are appealed beyond the district court, and they're arranged in 12 circuits kind of throughout the United States. They are only appellate in nature. The Constitution is silent about the qualifications of federal judges, only that they can be appointed by the president with advice and consent of the Senate. Federal judgeships are rewarded on a few things: rewarding political friendship, supporting and cultivating future support, and ideology. An important qualification is they usually identify either ideologically with the president that appoints them. At the very top of our system is the Supreme Court. They don't wear the elaborate wigs that the British House of Lords do, but they do wear long black robes and sit against a background of red silk. This is perhaps the closest thing we have to pomp and circumstance in our government. But the Supreme Court typically gets the highest approval ratings in the United States, but don't really suffer from the cynicism about government that affects other branches. They're political in four different areas, though: how they're chosen, how they decide what cases to hear, how they make decisions, and the effects of these decisions. In the perfect world, we would select the wisest, most intelligent jurist in the country to be on the Supreme Court. But it's a political world, and we need the wisdom and intelligence to be balancing at the demands of a system that makes those justices the choice of an elected president and confirmed by senators. It's not that different from choosing a federal judge as it is from choosing a Supreme Court. but the president still wants to nominate the most qualified person with the highest ethical standards who also meets other things. The FBI is going to check their backgrounds, the ABA is going to comment on their legal background, and the president wants them to have the similar ideology to who they are. They can either be a strict constitutionalist, which is a judicial approach holding that the Constitution should be read literally with the framers' intention in mind, or judicial interpretivism, an approach that the Constitution is a living document and the judges should interpret it according to changing times and values. Most people who are nominated to the Supreme Court have been personally acquainted with the president. Sometimes the president wants to appoint somebody because they are representing a group they should be included in the political process, or whose support they want to gain. Like LBJ appointed Thurgood Marshall because he wanted to appoint an African American. Then they also have to be confirmed by the Senate. The Senate Judiciary holds hearings, and then they have a full vote on the floor. The Supreme Court has to choose what cases to hear. There are political considerations there as they decide what cases to hear. And then when you are petitioning the Supreme Court to be held, you have to have some sort of political favor almost. Almost all cases come to the Supreme Court from an appellate jurisdiction. Virtually all arrive in the form of a petition for writ of certiorari, which is a formal request to call up a lower court case it decides to hear on appeal. Law clerks play a vital role. These are usually recent grads from law school who have a tremendous responsibility to read all these cert petitions. They read them all and decide which cases are going to be held in front of the Supreme Court. Once a case is on the discuss list, then they have to vote on 4 justices to grant it certiorari. This is the rule of 4, the unwritten requirement that 4 Supreme Court justices must agree to grant certiorari for it to be heard. Whether the United States is a party of the case, or if they are influenced by the amicus curiae briefs, which are the friend of the court documents filed to encourage the court to grant or take away certiorari, affect the likelihood of the case being heard. And then once a case is on the docket, the parties are notified and they prepare their written briefs and oral arguments for the Supreme Court appearance. Judges are influenced by the view they hold of the Supreme Court. Are they going to be activists? Do they view that the court should be lawmaking, policy-making bodies? Or do they have judicial restraint, that courts should reject active lawmaking and stick to the judicial interpretations of the past? Some external forces are that judges tend to make decisions consistent with the majority of opinion in the United States. They are shaped by the same things that we are. They're still reading the newspapers in the mornings like we are, or their news on their phones. Once a decision is reached, the writing of the opinion is assigned. An opinion is the written decision of the court that states the judgment of the majority. This is the lasting part of the process that's read by law students. A concurring opinion is a document written by justices expressing agreement with the majority. A dissenting opinion is a document written expressing disagreement with the majority. There are many political effects of these decisions. Had John Marshall really enhanced the power of the federal government by declaring that the Supreme Court has power to invalidate state laws. And then, thinking about the citizens in the Supreme Court, do we have equal treatment and access to our system? The central question is, who takes advantage of our system for allocating resources and values? An important principle is equality before the law. Should all citizens be treated equally, or should we have equal access to the law, or both? We should all have, we have public defenders who represent folks who are not able to represent themselves in courts. And then in the civil system, we have something called legal services to help folks who are not able to have their own legal assistance. All right, that was the courts and law school, my quick and dirty. I will get back to you soon with our next chapter, and then I'll post your quiz later on. All right, thanks, guys.